Respect for human rights is one of the hallmarks of any free and democratic society. In this video, we will be exploring their role within the European Union and how they relate to an important principle, which is the rule of law. But before all this, we will briefly consider what they are and why they are important. Human rights gained global recognition after the horrors of the Second World War that led to the creation of the United Nations and the adoption of the Universal Declaration of Human Rights in the 1940s. Human rights are the basic freedoms and protections that all individuals enjoy simply because they are human. Normally, we tend to group human rights into four main categories. These are political, civil, economic, and social. When it comes to political rights, these are human rights that empower individuals to participate actively in the political life of their country. So here, for example, we will find rights such as the right to vote, freedom of expression, and freedom of assembly. When it comes to civil rights, these are aimed at ensuring that individuals' lives are treated with dignity and respect. So here we would find rights such as the right to life, freedom from torture or inhuman treatment, the right to privacy, the right to a fair trial, and freedom from discrimination. Economic rights, on the other hand, are aimed at promoting an individual's economic security and ability to have safe and fair working conditions. Similarly, social rights ensure that individuals have access to important state services and resources such as the right to education, the right to healthcare, and also the right to housing, among others. Although they address different aspects of an individual's life, these different categories are interdependent. So, for instance, civil and political rights can be used to demand the introduction or reinforcement of economic and social rights. While some rights are absolute, in other words, they have to be respected at all times, certain rights can be subject to certain limitations. For instance, freedom of expression, which is the right to impart ideas and opinions without fear of repercussion, cannot be used to incite violence. Similarly, freedom of assembly, which is the right to protest in a peaceful manner or to demonstrate in a peaceful manner with others without interference, cannot be used to put the life and safety of others at risk or lead to a situation where there is theft or damage of private or public property. So, freedom of expression and of assembly, although they are essential rights in a democratic society and ensure the proper functioning of a democratic society, they need to be limited in certain circumstances. They have to be balanced with other interests, including the rights and freedoms of others. So, in a way, human rights not only shape the way we live or have a profound effect on our lives, but also shape how we interact with others so that we can live in a stable and peaceful society. Like the rule of law, respect for human rights is one of the core values of the EU, which are enshrined in the Treaty on the European Union. And like the rule of law, it is also one of the requirements for EU membership. In other words, any country that wishes to join the European Union must demonstrate a commitment to human rights. In fact, these countries must have first signed up to the European Convention on Human Rights, which is a very prominent post-Second World War bill that binds 47 European countries. Despite this, the EU has its own Bill of Rights, known as the Charter of Fundamental Rights of the EU. This charter brings together a number of political, civil, economic, and social rights, such as the ones we discussed earlier and more, and it brings all of these rights into one comprehensive document. The Charter came into force in 2009, and it binds EU institutions and the EU member states. When it comes to the EU institutions, one of the most prominent effects of the Charter is its ability, or the fact that it can be used to annul and has been used to annul EU legislation that is incompatible with the Charter. When it comes to member states, these are bound to comply with Charter provisions only when they are implementing EU law. So, for example, if a member state has enacted a law or is implementing a law that is based on EU law, it then has an obligation to respect the Charter provisions. And if it fails to do so, it can face legal action before the Court of Justice, and if the court finds a violation, it will impose penalties and fines. It can impose penalties and fines on the member state. Individuals can also ensure that national law that is based on EU law is compatible with the Charter. They can do this via an action in the national courts, which are bound to and then check whether the law in question is compatible with the Charter, and if not, enforce EU law, including the Charter. In other words, the Charter would prevail over that national piece of legislation. That member states are only bound to respect the Charter provisions when they are implementing EU law may sound like a limitation. However, member states are still bound to the protections enshrined in their national constitutions, as well as the obligations they have pursuant to perhaps other international and regional human rights treaties that they have signed up to, including the European Convention on Human Rights, which we mentioned earlier. So in purely domestic affairs not related to EU law, there are still certain safeguards. Also, if a member state engages in widespread and systemic human rights abuses, the EU can, for instance, suspend that member state's voting rights in the Council pursuant to a procedure which is enshrined in Article 7 of the Treaty on the European Union. And this applies irrespective of whether these abuses are happening in an EU law context or not. And this reason goes back to what we mentioned earlier, the fact that respect for human rights is a founding value of the EU and also one of the requirements for membership. So the EU cannot accept a situation where its member states are now losing sight of the very conditions that made them eligible for membership in the first place. And this can also affect cooperation between the member states themselves in areas such as those related to criminal and civil justice, in which human rights issues such as the right of a trial tend to crop up. Member states with a strong commitment to human rights may be reluctant to cooperate with a member state in these years if it feels that member states' human rights standards fall severely short of their own. However, even before there was a formal charter, human rights were recognized in the European Union through what we call the general principles of EU law. These are a set of unwritten rules that are inspired by the constitutions of the member states and also international human rights treaties. These unwritten rules act as a standard which the EU and member states have to satisfy and against which their actions could be scrutinized. The Court of Justice of the European Union played a crucial role in establishing these general principles of EU law. Through its judgments, which date back to the 1960s, human rights gradually became part of the European Union's legal order even before a formally binding charter. Human rights and the rule of law mutually reinforce each other. The rule of law provides a framework that protects human rights. For instance, it ensures that courts are independent and can hold powerful actors accountable if they violate human rights. On the other hand, if the law is to be above everyone and everything else, as the rule of law requires, human rights ensure that at least the law itself is fair and just. Human rights can also come to the rescue of the rule of law if this is under threat. By exercising our political rights, for instance, we can force competent authorities to change course. And also, there's a point where human rights and the rule of law actually intersect. This is the case with regards to certain human rights, such as equality before the law, the right to an effective remedy, the right to a fair trial. which are, in a sense, part and parcel of what constitutes the rule of law. All this is not to say that human rights violations do not occur. On the contrary, human rights are under pressure everywhere, including in places where human rights are supposedly strongly ingrained. One of the things that we can do is not to take them for granted. Many of us do not remember a world without them. For this reason, it is easy to think that they are a permanent fixture in our shared human experience. This is unfortunately a misconception. Their longevity does not guarantee their survival going forward. This is why we should elect representatives at both a national and regional level that demonstrate a strong commitment to human rights for all and not a select few, and to apply pressure through our political rights whenever they waver from this commitment.